The latest circus act in the Cayetano Senate is the attempt to allow members to vote in absentia, an obvious ploy to allow Senator Bato de la Rosa to take full part as a majority senator even while hiding from the law. The lengths this new majority would go through just to protect Bato. Are there no limits? Have they no shame? Hi, I'm John Nery and you are in the Public Square. But there are, in fact, limits. The Supreme Court, in denying Senator Bato de la Rosa's petition for a TRO, and the Solicitor General, in her comment on Bato's petition, made vitally important distinctions. Our guest today is a lawyer and a public intellectual who brings a welcome clarity to legal issues. Aside from his distinguished legal practice, Dean Mel Sta has also served as Dean of the Far Eastern University Institute of Law for a decade, and as a law professor at the Ateneo de Manila School of Law since 1986. Welcome, Dean Mel, and thank you for joining us in the Public Square.
My pleasure, John.
Let's start with the May 20 resolution of the Supreme Court. What did the court say?
Well, the court, in its main resolution, dealt with technicalities. Because in wanting or praying for a temporary restraining order, the Supreme Court said there are 4 elements.
Okay.
There must be, first, a clear, unmistakable right. They call it right in esse. And number 2, there must be an invasion of that right. And number 3, there must be no remedy at all, no available other remedy. And number 4, there must be an irreparable injury to the one seeking the TRO.
Okay.
In all those aspects, the Supreme Court, we did not find any.
Okay.
Because there was no clear legal right, because the main issue on the validity of the warrant of arrest, Section 17 of Republic Act 9851, are still to be decided in the principal main case.
Okay.
So there is no clear right. There having no clear right, then there is no both irreparable injury and no invasion. And there are other proper remedies. And as a matter of fact, the Supreme Court said you are protected. The legislator, the Senate particularly, gave you a Senate protective custody and so forth. And there was an announcement by the president saying that there will be no arrest at that time. And so there is no invasion, you are safe. So they didn't find any reason to grant the temporary restraining order. So it's really very, very technical.
Yeah.
A stoic, rigid, rule-based resolution.
Yeah.
But that's the main resolution.
So it's very straightforward, no? I mean, as a non-lawyer reading it, I see that Bato de la Rosa raised arguments corresponding to each of the 4 elements.
Correct.
And then the Supreme Court just knocked them down one by one.
Right. First, second,
So
third,
parang
fourth.
wala masyadong palabok.
Wala. Talagang straightforward, talagang walang arte-arte. Ito, wala talaga kami nakita. In short, that's the main feature, appearance of that resolution.
Okay. But in the very end, may patama din yung Supreme Court. May sinabi sila na yung petition, yung very urgent manifestation ni Senator Bato was filled with unverified reports and allegations.
It's speculative. It is an imagined things. No? So isa pa yun, no? Parang sinasabi, well, nothing. There's absolutely no evidence at all for this urgency that you are praying for, no? The TRO.
Parang the Supreme Court was saying, we are not a trier of facts,
Correct.
but what your allegations are don't even rise to the level of facts. Parang ganun ba?
Correct. And if you are trying to insinuate that there are facts, you are giving us secondary sources, not even the main sources, like videos, like tapes, like newspaper reports, sabi ng Korte Suprema. So on those flimsy factual reasoning, quote unquote, sabi ng Supreme Court, they could not just issue that TRO.
Did the resolution and the ruling here, did it surprise you or did you expect it?
Well, in a way, I expect it. But what surprised me was the votes.
Okay.
Because I thought all the while that it was a straightforward case.
Okay.
It was such a straightforward case that there is that presumption of regularity of government action.
Okay.
There was the NBI, government people, serving the warrant of arrest. The clear delineation of the separation of powers can be seen at the moment between May 11 and 14. I mean to say, because, you know, in a democracy like ours, we disperse powers to avoid dictatorship. We have the legislature enacting laws, the judiciary deciding cases, and the executive executing law, peace and order, issuing serving warrants of arrest. At the very moment, at that very point in time when the service was being made, we could only see one functional work of government, which is the executive.
Okay.
The legislature was no longer legislating at that time, was no longer in an impeachment trial. So, and therefore, the one we could see executing a government function was the executive serving a warrant. So if you really look at the clear delineation of power and you respect the domain of each one, I thought that the respect should have been in favor of the executive.
Okay.
So that therefore I thought it was a clear shot case.
So it's the dissents.
So yes,
That surprised you?
It's a dissent that surprised me. 951 means that when they were deliberating, they were battling.
Okay.
They were going back and forth. It was not, well, I would just speculate, but it was not a peaceful, probably discussion. No? It was a heated one, 951. And in the 9, there are, you know, there were very careful concurring opinions. No? In the dissent, it was straightforward, and then one was on leave. So I was surprised by the vote, actually.
Okay.
I thought it would have been larger than 9. I thought probably it would have been unanimous at that time.
Okay.
But it surprised me. Yeah.
At this point, maybe I should just remind the audience that Dean Mel has argued before the Supreme Court.
Oh, yes.
As counsel and also as amicus curiae.
Yeah,
that's right.
yes.
So you would have a feel for how these things go. But there are also separate concurring opinions.
That's correct.
I'd like to go through them. But before that, I wanted to maybe spend a few minutes talking about the 83-page comment filed by Solicitor General Darlene Berberabe.
Yes.
I was one of many who followed your initial impressions when you posted them on social media. And if I'm not mistaken, it was in fact cited and favorably in both the ruling, in the resolution, and in some of the concurring opinions. No? Can you give us your overall impression of the comment from the Solicitor General?
The Solicitor General contextualized the Constitution within the framework of international law.
Okay.
She started by saying that we have crime against humanity, and that is in international law. And international law, according to our Constitution, is part of our law of the land. We accept generally accepted principles of international law.
Sure.
And so that therefore, we have international law, and then the Constitution can be harmonized. And then you have Republic Act 9851, our crime against humanity law or statute. It is the bridge towards that international law. It's the connect.
Yeah.
And so that therefore, in Section 17 of that law, it says that in the interest of justice, the Philippine government, if an international tribunal is already hearing or investing the case, we could waive our jurisdiction and give the investigation to them. And if need be, we could surrender or extradite the suspected person. And according to the Solicitor General, and this was a very good argument, it was a political act. It was a choice given to the executive department, of which the judiciary and the legislature should have no part. That was an executive act. And so therefore, being an executive act and involving foreign affairs, and since the president is the premier foreign affairs officer of the land, we should give great deference to his action. And so, since it's a political act, then we must respect it. And when the president recognized, or the executive department recognized that particular body, the ICC, the International Criminal Court, we likewise recognize its processes. And when we recognize its processes, we recognize its judicial determination of probable cause and the ultimate issuance of a warrant of arrest. And so that therefore, and this was the Solicitor General's statement, and so that therefore there is no need for a second judicial determination of probable cause because precisely we recognize ICC, we recognize the process, we therefore should recognize the warrant as valid. So you see the harmonization by the Office of the Solicitor General among these three legal systems, no? The international law, our constitution, and domestic law. She was really able to connect it, and of course, then she said, "But you know what? Republic Act 9851 came even before the Rome Statute. It was 2009, so it could." Come to think of it, it could exist independently of the Rome Statute. So take away that Rome Statute, it's still the bridge toward international law. And even international law has four sources. So she referred to the Nicaragua case. In the Nicaragua case, the Supreme Court said, there are four sources of international law: treaties, customary international law, general principles of law, and statement of well-renowned authorities. Take away the treaty, you still have customary international law. And we are bound by that customary international law because crime against humanity is a universal crime. So therefore, the discussion was really very fluid. And then, of course, it was an opportunity for the Office of the Solicitor General to again restate the narrative of EJK. And therefore, it was such a powerful comment actually by the office.
And it also has a very powerful section on unclean hands.
That's correct, yes.
Bato could not be granted his petition because he came to the court with unclean hands.
Yes, because
what does it mean?
Because there is a rule in litigation that you must always come to court with clean hands. A person in bad faith has absolutely no remedy. And so that was what the Office of the Solicitor General was trying to say. No, he went to the Senate not because of any profound reason, but for political convenience. To vote and change the leadership. That's all. And then thereafter, he went away again. So you see, it's just for political convenience, the OSG said. So there was really nothing profound there. So that comment of the OSG was fluid, coherent, powerful, and really putting the context of our domestic law within the framework of international law.
I want to step back a bit and ask you about this particular concern of mine. When we started reading the comment of the Solicitor General, some of my fellow journalists said, okay, maganda, beautiful words, but if nothing happens, no, parang naglolokohan lang tayo dito, no? The fact that it's fluid, it's coherent, it's a very powerful restatement of very key principles, that already counts for something, right? I mean, I don't want to be too cynical and say, so parang, okay, what good will that do?
Well, first of all, from the educational point of view, no? Then we see, for example, that you don't have to make domestic law and international law contradict each other. No? There is a point in harmonization of these laws. And number two, it also signifies that we really have to accept that we live in a connected global community. And that there are certain crimes that has been categorized all over the world as crime against humanity. And people could say, but we could try it here let's just charge them with murder. But you have to emphasize the gravitas of the crime. It is a global crime, so people have to be educated also on that. And also, it is facing reality. Imagine, John, I can bet that no fiscal office or court here in the Philippines as of today is trying any crime against humanity. Zero. We have absolutely no experience. So this sovereignty card, so this nationalistic card, so this, why do we have to let foreign judges try Filipinos? No, that's not the point. The point is we have to face reality. There is no such expertise in the Philippines, and that is why Miriam's Defensor Santiago, Richard Gordon, those who sponsored this law were visionaries. They really thought of, hey, why not let them do it? Give it to the experts, both for the benefit of the accused and the victims, because crime against humanity has a different paradigm. So let them do it first. And second, stability-wise, if you try it here, you know, on both sides, there will be rallies probably in front of the courts, and probably nothing will happen, postpone, and of course, the perception of our justice system. Alam mo naman, dyan, may bulong-bulungan dyan, nabibigyan, na-impluensyahan, na-apektuhan. So probably, from the sense of geography, stability, practicality, and pure common sense, mukhang tama yung ICC. And that's the point. But once we're ready, why not? Parang ganon.
And the power of the Solgen's comment would be persuasive, I would think. Not only in educational circles, but even among the justices. I mean, just noting that she is quoted, her comment is quoted in some of the opinions.
Yes. In Kagiwa's opinion, in Singh's opinion, she was being quoted. Yeah, because it's a powerful one. No? And there are certain arguments, for example, you make before the Supreme Court, which is just perfectly correct, that there can be no substitute explanation. You know? So they just have to quote it. That's the point. She's correct. So.
Now let's go to the different opinions that were written. So we have 3 concurring.
Kagiwa, 5 concurring opinions. No. 9 concurring opinions. 5 dissent, and 1 on leave did not vote.
What would be the representative opinions here that maybe we can discuss?
I would say the concurring opinion of Justice Alfredo Benjamin Kagiwa. And that's the concurring. And the dissenting, that of Justice Ogier. And that, you know, that comfortable middle ground by Justice Leonen.
Let's start with Justice Kagiwa, whom you described the other day as probably the Oliver Wendell Holmes Jr. of Philippine law. No? It is a very powerful statement. But again, as a non-lawyer, I'm struck that he is coming from the perspective of the victims.
That is correct.
Sabi niya, history weighs here. No? And the heavy weight of history. And I thought, iba yung approach niya.
Correct.
Can we talk about
that? That is precisely the point. He discussed the other voiceless party. No, that is the distinctive feature of his decision. He placed it in a historical context. That's why, as I said, he's the Oliver Wendell Holmes of the Philippines, because Justice Oliver Wendell Holmes would always say, the law is history. You cannot divorce the law from the historical content which that law should serve. So Kagiwa was doing that, looking at the victims and looking at impunity and making powerful statements. Well, he reflected the fluidity and the connection made by the Office of the Solicitor General. But one point he really discussed was, people are saying that under the Constitution, no person shall be arrested without a warrant of arrest issued by a judge. And people are saying that the judge must be a local court. And he said, oh no, you cannot narrow it in that respect, no? Because that is precisely our adherence to international law. And that's why that is precisely the reason why we have a connecting statute. so that we could also say that that judge in the Constitution was not even qualified. It can be foreign or it can be local. And so that we have Republic Act 9851 to legitimize the determination of a foreign judge, because by a political act of the president, we recognize it. And it's such a fluid, yeah, right, she's correct. It's such a fluid argument, and that is already bearing on the merits of the case. Merits na yun. Kaya you know precisely where Kagiwa is right now.
Yeah,
he will be very, very consistent up to the end.
So Home Son, in the sense that he knows that the life of the law is experience, not logic.
Yes.
But also Home Son in the sense that he writes very well. He gives this very vivid metaphor.
Yeah.
We are not a politically convenient doormat.
Yeah, right. Very powerful, actually.
Yeah.
Very
So parang where you can just wipe clean the blood of the victim.
And he would say that, you know, injustice is everywhere, even in offices. Now in the invocation of due process. He even said that.
Yeah.
So we must be very, very, very careful. He said that.
He said also, equally important, the court stands at a crucial point in history where misplaced restraint may speak as loudly as judgment. What did he mean?
Okay. We have what we call judicial restraint. And that the judiciary cannot just insert itself into any kind of controversy. And that's why in our Constitution we have that expanded jurisdiction that the Supreme Court can in relation to government departments, intrude only in case of grave abuse of discretion. And so that, because of that, it implies that the judiciary must have judicial restraint. No? But sometimes, it is not probably judicial restraint, but judicial subservience, no? Something like that.
Or cowardice.
Or cowardice, or utang na loob, no? Something like that. So we really have to be very careful, according to him, without even explaining it so in detail. I think people can get the message.
So what he's saying is, at this point in time, we need the Supreme Court to be loud and clear about what's at stake.
Yes, and he said that this is a defining moment. Defining moment, and I guess we'll talk about later, defining moment in relation also to... So from the Philippine points of view, what do we think of our sovereignty? No? So we have two philosophies again on sovereignty. Is it a sovereignty that is accommodating to international law? Or is it a sovereignty which is so selfish that it will always be a check against the progress in international law? That's the balance.
Let's go to the dissents.
Yes.
So there are 5 of them. Before we go into Justice Javier's dissenting opinion, is the argument of the dissenters weakened because there are 5 dissenting opinions, or there's another way of looking at this?
Well, numerically, when you say 5, they are the less sides. So in a sense, they were overpowered by the majority opinion. Merit-wise or wisdom-wise, you know, then you could probably argue that wisdom-wise or merit-wise or argument-wise, then it depends on how they approach or they approach the problem. No?
Okay.
And so if we talk about, for example, Justice Javier, it is my opinion only that she was really ultra-constitutionalist. No?
Okay.
She described, for example, the ICC warrant of arrest as an alien warrant.
Okay.
No, she describes, for example, arrest by executive fiat.
Okay.
No, so you could see the parochial nature of her dissent, that you should go first through the process of the Constitution. No? In short, the Constitution is the legitimating factor for any recognition of international law. I think the basic premise is, yes, you have international law, but the Constitution is over and above everything else, including international. Whereas Kagiwa says, no, it's Constitution and international law are blended together to harmonize each other.
What would be the implication of that if Justice Javier's view is or becomes the prevailing one, no? That the Constitution is above our commitments to international law. How would we? What would that mean?
That would mean that the ICC warrant of arrest will be that our judiciary will have an oversight power over international tribunal, though recognized by the executive department. So this is, in a way, what you call judicial supremacy. That the justice system must legitimate any international process. That is the meaning of that. So it could say it's invalid, we will not enforce it.
Would it be the right analogy to think of our victory at the arbitral tribunal over the South China Sea disputes and point to China? Okay, it's not judicial supremacy, but China's national interest forbids it from acknowledging the victory.
Yeah. Yes, no. But when you talk about China, you talk about power. You talk about power. And when you talk about, the executive and the judiciary and the legislative, they have technically equal powers. But since the judiciary decides cases on grave abuse of discretion, so really there could be a semblance of judicial supremacy in this particular case. Again, judicial overreach. Again, questioning the wisdom of executive acts. So that will be the repercussion. And therefore, the judiciary will always be the legitimizing factor in relation to international processes.
Would that argument be possibly the core argument that might attract some of the other justices, to cross? Or is there another, even more powerful argument among the dissenters?
Okay. I think the argument of Justice Kiguiwa is quite strong. And also Javier, he has logic and she has her constitutional preference. Looking at another justice, I'll now go to Justice Leonen.
Yes, please, the middle ground, as you say.
The comfortable middle ground, the way I take it. He agreed on the denial, basically on what was said by the resolution. On technical grounds, it should be denied. But then he went further. He went further and sort of told everybody, this is my thoughts. These are my thoughts. Sabi niya ganito, when you talk about international law and constitution and domestic law, sure, they must complement. Sure, they must harmonize. But then, our constitution must be a little bit higher. Because when you recognize international law or an international treaty, it goes down to the level of a statute. And in our laws, there is a hierarchy of statutes. We have the Constitution, statutes by the legislature, and rules and regulation. It goes down to that second rank when we recognize. And so therefore the Constitution is high. And so that therefore if the Constitution should be treated as the superior law, then we have to abide by what the Constitution said. And implied in the Constitution is that we must respect our own procedure, judicial and executive procedures in apprehending a person. And so that again, and when Justice Leonen discussed that one, he even highlighted that part of his opinion, parang sinasabi niya, all the procedures, inantay ko, all of the procedure, including its outside outlines, yung talagang sagarin nyo hanggat ma-exhaust nyo. Kung hindi, it's
the legal remedies available here.
Yes. Kung hindi, he will grant that petition. Parang iyan yung take. And the other thing he said was that the remedy here was habeas corpus. Habeas corpus. Habeas corpus is a remedy when an entity takes into custody a person and somebody alleges that it is an illegal detention, and so that therefore you file a habeas corpus case. But what is significant in an habeas corpus case? Normally, when you file a petition, the burden of proof first is on the petitioner. I will prove that all my allegations, all my prayers should be followed because these are my allegations, I'll prove them. But in a habeas corpus proceeding, the first order of the judge is this. You, respondent, show cause. Show cause why that person shall not be deprived from you. And so that therefore you will see the burden of evidence shifts no longer to the petitioner, but to the respondent. And so it, I don't know if, so the way I look at it, the first burden is on the respondent. So you have to prove, did you exhaust everything? Para lang sa akin, konting miss out lang dyan, did not exhaust. So we cannot avail of the ICC. Exhaust it first.
Somehow this reminds me of his ruling on Sara Duterte's first impeachment.
Yeah. So that's it. Sabi ko, wow, what a clever thing to say. But maybe that's only me, no? Kasi sabi ko, ibang habeas corpus eh. Talagang bumabaliktad ang burden, nag-shift ang burden dyan. Di ba? Ngayon, si Bato nagpo-prove. Sa habeas corpus, government, prove your point. Prove that Section 17 is valid. Prove the element of complementarity. Prove that you have exhausted everything. If you don't prove that, habeas corpus will be sustained. Bato, go out.
Dean, you don't need to answer this, but you said earlier that from the way that Justice Caguioa argued, you could already see where he's coming from, and then you can anticipate that on the merits he will be very hard on Duterte and Bato, the petitioners in that particular case. Can you also anticipate how Justice Javier will vote on the merits and how Justice Leonen will vote on the merits based on their opinions?
Based on their opinion only? I think Justice Javier, she will maintain her course.
Okay.
Justice Leonen, with all due respect to Justice Leonen, based only on what he has said substantially on international and domestic law.
Okay.
I think at this moment, I'm inclined to believe that he is poised to say that the petition should be granted.
Wow.
Bato can get out. Okay. Local remedies, do your work before we accede to the international ICC.
Right.
That's my perception.
Okay.
Baka narinig tayo ni Justice Lawrence. Sorry, Justice.
Yeah, well, interpreting his decision. Yeah,
yes,
right?
yes.
I was also led to study Justice Singh's opinion because I saw many of people I follow on social media also point to it. No? And I think her very first paragraph says, we must not be captive to informational panic or procedural absolutism. What did she mean by that? Were those the two approaches to the TRO issue?
Oh, yes. Because this is a global crime. This is a global crime against humanity. You cannot vindicate aggrieved people because of crime against humanity through total adherence to domestic procedures.
Okay.
Even, meaning to say, domestic procedures will not necessarily solve a global crime because there are just so many things needed in a crime against humanity. Yun ang sinasabi niya.
Okay.
So ito yung parang ang turing ko naman dito, some justices or judges has this, procedural fetishism. Alam mo yun, yung these are the law, these are the strictures of the law. Nothing, we cannot get out from this law, comply with everything. But justice, the rules must serve justice, no? Yeah. Not the other way around. Kaya you can be flexible, you can look at, you can transcend. So that's what she means. I believe that's what she means. If you're so over-obsessed with complying with domestic rule to answer international accountability, you will not reach it because there will always be obstacles.
Okay.
Yeah.
So a warning against procedural fetishism.
Yes.
But she also said something that struck me. No public official can wear the oath of office as an armor against liability. Medyo,
Yes.
I mean, directly, to the status of Bato de la Rosa as an incumbent senator.
Yeah. You know that.
What do we make of that?
That's. I think he was, or she was watching. She was watching what transpired from May 11 to May 14. You know what we saw? What we saw, John. Why people got angry? It's because we were witnessing the powerful protecting the powerful. We just saw that, man. Powerful protecting the powerful. They're all in the same place. Number two, we just saw that tribal mentality. If you are with this group, we will protect you at all costs. Even making a sort of resolution without basis in law. Okay. And in the Constitution, that sanctuary thing. Yeah. That's two. Yeah. And number three, that kind of feudal attitude where you have to associate yourself with a high person, political person, to be able to get some sort of a justice or delay of justice. We were witnessing that. Yeah. And I think that was what she meant. No? A shield. No? We all saw that, and that's why we all got angry. It's not even the legalities of everything, but, the double standard, it's real.
Yeah.
That is what we saw.
The law applies to other people.
Yes,
not
yes.
to us.
Not to us. Now, imagine.
That's what we were so angry about.
Right, yeah. You're shouting, due process, arrest the criminals. When you reach the door of the Senate, okay, stop. Just stop. How could you do that? And it was a hot pursuit thing. Hindi ka naman, alam mo, ganito yan eh. Kung sa private house at may warrant of arrest ka, ang gagawin mo according to the rules of court, tutok-tok ka muna, itimbre ka. Tao po, may warrant of arrest kami. At kung hindi ka papapasukin, a little bit of force can be done. But this was in a public place, either owned by the government or rented by the government, and it was a hot pursuit. Kasi basta hot pursuit, talagang pwede mo siyang habulin. And yet, when it reached the Senate, everything stopped. And the powerful protecting the powerful. That was the...
I was so encouraged reading many of the opinions interpreting what happened in the Senate as actually unfavorable to Bato. Right? In fact, quoting the Solicitor General, no? You went into hiding for 6 months to avoid being charged, and then you show up just to vote for a replacement.
Yes.
And then you leave right away.
Right.
Which, first of all, meant that you're doing things out of convenience, but then also that you had enough freedom to walk in and walk out.
Oh yeah, that's correct. Precisely. And with so many help from so many friends. So the power aspect is there.
Yeah, the powerful protecting the powerful. Maybe just a couple more questions, and I'd like to zoom out this time. What should we, as ordinary citizens and non-lawyers, take away from these opinions?
Okay. Number one, that we have to reevaluate or reassess even the judiciary. The judiciary can make up decisions which may be diversified, which may antagonize each other, but we know when the decision comes, well, we take it on the chin, but it should not prevent us from criticizing decisions of the Supreme Court because it is not immune from criticism. They're just like ordinary public officers making decisions, and their check, and their immediate check is our response to their actions. No, we write, we speak about them, we use social media saying they're wrong, etc. Because that's legitimate, and that's what we have to learn from this experience. No?
What about the Senate? Is there anything in the resolution itself, or the separate opinions, or the dissents that can be read as a message to the upper chamber?
Of course, there is. Remember, one resolution says sanctuary, one resolution pending says Bato, surrender. So it gives now this non-granting of the TRO gives a certain moral ascendancy, so to speak, of that Bato, mag-surrender ka na. And it will clearly tell you, through this decision, at this point in time, sinong tama. Diba? Hindi ka na yung nagwe-wake ka pa. Ang tama pala, mag-surrender ka na kasi hindi naman pala gumawa ng pagbabawal ang Korte Suprema. And the President of the Philippines must also take some cues here. Diba? I mean, yan, exert your effort in engaging with international agencies to facilitate crime against humanity. Or at least magsalita ka ng konti. Kahit na pasaring dyan, pasaring dito. Di ba? Huwag ka namang masyado maging tahimik. Di ba? And so yun, those are the things we could get from this experience.
What about the new Senate majority's decision to offer protective custody, which in many of the opinions was in quotation marks? Parang nakasama pa yata doon kay Bato.
O yun sabi ng sa main resolution. You are even protected by that so-called sanctuary by the Senate, no? Na protect. So where is the irreparable injury? Where is the invasion of your right? Sabi ng Korte Suprema. Nakasama pa.
So the message would be to the Senate, I mean, think things through.
And yeah, most of the time, no? Kasi you could just imagine, no, yung experience, I don't know, maybe, dun sa ICC, bago madesisyonan yung interim release, first interim release ni Duterte, gumawa sila ng resolution na house arrest na si Duterte. It just shows you the power of a great department of the government in the Philippines, still allied with Duterte. So kung papauwi natin yan, hindi na babalik yan. And so ito, parang timely. Another one, just 1 or 2 years ago, dininay na naman. Probably they saw what happened to Senator Bato. He was being protected by the government. So nothing changed. Sabi ng ICC, nothing changed. Let him stay.
I think that's one thing that many of Duterte supporters don't appreciate. That the international community is in the Philippines.
Yeah.
I mean, they have eyes and ears here, listening posts. They know what's happening.
Right. It's
a small world.
It's a small world already. We are all connected, no? Just one click of that of the computer. Liligid na yung news na yan.
This has been highly illuminating for me, and I hope for our audience too. Dean Mel Santa Maria, thank you very much for joining us in the public square.
Thank you very much.
And that's it for us today. The challenge for engaged citizens remains the same: to defend and to fully inhabit the democratic space. Please download the Rappler Communities app and join the chat room of your choice. And if you haven't yet, subscribe to Rappler Plus. Thank you. This is John Nery. See you in the public square.